FC stands for
faculty.
Achha. Good morning, Justice Jain. How are you?
I'm fine, thank you. How are you?
Good. Good morning, everyone. This one-day workshop on commercial courts is a venture being organized by the Chandigarh Judicial Academy. The Commercial Courts Act, the assent was given to it on the last day of the year 2015. And thereafter, under this particular enactment, commercial courts, commercial appellate courts at the district level have been constituted. Similarly, the commercial division and commercial appellate divisions have been constituted in the high courts across the country for that matter. The commercial courts have assumed significance during the last 5, 7 or 10 years as such, and therefore it was considered by the Parliament to have a legislation to deal with the issues relating to the commercial courts in a short manner and yet effective dealing of those particular matters. This required a separate legislation providing for different aspects as such, so that effective commercial disputes adjudication could be carried out at different levels across the country. And therefore, the issues which concern the commercial courts are going to be discussed in this particular one-day workshop. This workshop has been divided into 5 different sessions. The first session is being devoted to why commercial courts, the contours of jurisdiction. And for this particular aspect, we have with us this morning Justice R.K. Jain, a former judge of Punjab and Haryana High Court, a blend of a lawyer and a judge. A lawyer for 24 years and a judge for 13 long years. Therefore, Justice Jain brings 37 years of experience of the bar on the bench. What a combination. To cap it up, recently, Justice Akhijan was appointed as the monitoring judge in Lakhimpur incident by the Honorable Supreme Court to monitor every aspect of the investigation. And this particular task has been completed by Justice Jain in speed time. The report has already been submitted in this particular context. Therefore, we could not have thought of a person better than Justice Akhijan to deal with this, particularly the introductory aspect as to why commercial courts and the contours of jurisdiction. We are so very happy to have Justice Jain with us this morning. May I request Justice Jain to take oath.
Thank you, Dr. Gupta, for your kind words. Good morning to all the participants. Today's subject, which has been assigned to me by the Judicial Academy, is to introduce all the participants to a very important legislation named the Commercial Courts Act 2015. I have to tell you about the overview of the Act, jurisdiction part, the specified value, what is the commercial dispute, and of course the statutory remedy of appeal. We have always been, all through been, dealing with the civil suits, generally of the nature of the suits for declaration, where the party filing the suit asks for a declaration from the civil court of an existing right which is denied by the party opposing it, and civil suit for permanent injunction, where the party filing the suit tries to protect its possession from the party's opposite party trying to invade it. There are many hiccups in the final verdict in the ordinary civil suits because of the delays caused by the interested parties, which starts from the service of notice and ultimately completion of pleadings, where numerous adjournments are sought by the parties to the litigation, either for filing the pleadings or for correcting the pleadings, be it in the complaint or the written statement. And then the use of statutory remedies, like of civil revisions in the High Court against interlocutory orders, and ultimately the second appeal, which is used to be filed under Section 100 of the CPC. All this process takes a huge time, not only of the courts but also of the litigants. Earlier also, till the Commercial Courts Act 2015 was not introduced, suit for recovery, etc., which is now part of the Commercial Courts Act, were filed before the ordinary civil courts. But lately it was realized by the stakeholders that in order to invite direct foreign investments, and also to encourage public-private partnership, dedicated courts are required in India. Our leaders have been visiting various countries, inviting Indian diaspora and other foreign investors to invest in our country so that there may be a generation of the employment, not only generation of the employment, but also our GDP may also increase. But every now and then, there used to be a question asked by those prospective investors about the Indian judicial process, judicial system, which according to them is quite tardy. They had experience of filing civil suits in the ordinary civil courts, where if a stay is granted for any reason, whatever, it is not vacated for years together, because there are so many ways and means available to the advocates, learned advocates, who take recourse to the provisions of the procedural law of CPC. In order to plug that delay which is being caused and experienced in the ordinary civil suits, the Government of India thought of bringing a new legislation, a central legislation for the purpose of deciding commercial disputes. And in that process, started in the year 2003. And after various reports of the Law Commission and discussion on the bill, a central legislation came into force on 23rd of October 2015, applicable all over India, and was nomenclatured as the Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2015. As I have mentioned to you, that the purpose of bringing this legislation is to cut short the delays, which are basically procedural delays. So while we are talking about the overview of the Act, I may mention here that this Act has special features. The commercial courts have been constituted. They have been asked to decide the civil suit filed before it within a period of 60 days. Similarly, if an appeal is filed, it is also made time bound to be decided within 60 days. As a matter of fact, it is a very fast track court which has been designed and dedicated for the purpose of deciding the commercial disputes. We have experienced as a judge that in the civil suit filed, in an ordinary civil suit filed, there are many applications filed by the parties to the litigation from time to time. For example, if the suit is filed, maybe a suit for declaration, and there may be an application for amending the complaint, which is opposed by the other party, and ultimately it goes in revision, where it takes time to get it decided. So if we start with the correction of the pleadings, and then we have seen in the recent past that in almost all cases, application under Order 7 Rule 11 is being filed by the defendant. And those applications are being decided by the court as per the facts of the case. But in majority of cases, those orders are being challenged in the High Court in revision petition. This causes a huge delay in disposal of the main suit, which does not make any headway because of the pendency of the civil revision, in which sometimes stay is also granted. So in order to avoid this kind of a delay, the Act provides, and the Act says Section 8 of the Act says that there shall be no revision petition against any interlocutory order passed by the trial court dealing with the commercial dispute, be it may be the issue regarding the jurisdiction of the court. Generally, if the issue of jurisdiction is raised, it is decided at the earliest, so that the time of the court may not be unnecessarily wasted in deciding the case on merits. But in order to avoid some kind of unscrupulous litigant filing unnecessary revisions in the High Court, in the revisional court, the provision of revision has been abolished. This is a very significant aspect of this Act. The second interesting aspect of this Act is that it does not provide any second appeal. There is only one appeal is provided, that is under Section 13 of the Act, or to challenge the order, judgment. The word used in the Act is judgment and order, which of course judgment includes the decree also. So only one appeal is provided, unlike the procedure provided in Civil Procedure Code, where one appeal is provided in Section 96 of the CPC before the learned district judge, and the other appeal is provided under Section 100 of the CPC before the Honorable High Court. Thereafter, the party may use the constitutional exercise its constitutional provisions, Article 136, for the purpose of approaching the Honorable Supreme Court by filing special petition. Besides these interesting aspects of this Act, which is basically made for the purpose of cut short the delays, some lacunas were found in the working of the Act, and therefore in 2018 an amendment was brought in the Act, which was called the Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Amendment Act 2018. The amendment was brought on 3rd of May 2018, and with this amendment, the long name of the Act was shortened as Commercial Courts Act 2015. This is the first part which the legislature has done. Secondly, the amendment has brought down the specified value of the suit to ₹3 lakhs. Though it is provided there in the Act that it cannot be less than, the commercial suit cannot be less than ₹3 lakhs, but the upper limit can be fixed by the state government with the consultancy of the High Court. So you might be knowing, because most of you must be dealing with this commercial suits as a commercial courts, that somewhere the limit is 3 lakhs to 50 lakhs, and somewhere it is more than 50 lakhs. For example, the senior division, the judges, the additional district judges and additional district judges in some sessions divisions like Ludhiana and Gurgaon, Ludhiana in Punjab and Gurgaon in Haryana, have been given the jurisdiction to deal with the civil suits, commercial disputes of more than ₹50 lakhs as well. The commercial courts are then designated in terms of Section 3 capital A of the Act. Commercial courts at the level below the district level of the district judge. Those are the courts of the senior division, additional senior division, and junior division judges with 5-year experience, and the learned additional district judge and district judges who would have the original jurisdiction as well as the appellate jurisdiction of the decision rendered by the judges below that. The amended Act has also brought a very interesting amendment in the Act of 2015 by inserting Chapter 3 capital A. This pertains to which has brought Section 12 capital A in this statute. This is regarding pre-institution mediation and settlement. The stakeholders were not satisfied with the provision of 60 days granted for the purpose of trial and had thought that instead of trying the suit in the civil court and even for 60 days and then in appeal for another 60 days, the parties to the litigation may be asked to go for mediation if they are not asking for any urgent interlocutory order, interim relief. This pre-institution and mediation and settlement is basically aimed at avoiding even the courts at the first instance, so that if the parties, with the help of the mediator, comes to a settlement, then the award which is prepared by the mediator is to be taken as the award of the court, and it will finish all litigation in future as well. For this purpose, the authority for the mediation is provided under the Legal Services Authority Act 1987, and a notification has been issued by the Ministry of Law and Justice, Government of India, on 3rd July 2018, authorizing state authorities and district authorities under the Legal Services Authority Act 1987 to provide mediation. Now, how the mediation, this pre-institution mediation and settlement is to work, for that matter, rules have also been framed, which are called Commercial Courts Pre-Institutional Mediation and Settlement Rules 2018. Again, there was an anxiety in the mind of the stakeholders that unnecessary delays may not be there, even in mediation, because it is also a matter of experience that at the time of mediation, the parties sometimes are reluctant and try to take unnecessary adjournments or opportunities to consult and discuss, etc., etc. Therefore, it is statutorily provided that the mediation has to be completed within a period of 3 months, which can be extended for another 2 months in the specific case. So this is a very interesting and significant part which has been added as Chapter 3 Roman A in the existing statute, while inserting Section 12A with it. Now, besides this, the legislature had also thought originally to provide Section 17 in Chapter 7, which is a miscellaneous chapter of the Act, for the purpose of collection and disclosure of data of the filed, pending and decided commercial disputes. The purpose, and in order to achieve this purpose, the rules have also been framed, which are called the Commercial Courts Statistical Data Rules 2018. The purpose behind framing these rules and making Section 17 a statutory provision in the Act is to keep a check on the progress and success of the commercial disputes filed before the commercial courts, and also for its future planning. So the courts who are dealing with the commercial suits have to inform the relevant High Court under which they are working, and all the details about the filing, pendency, and disposal by the commercial courts has to be necessarily published by the relevant High Court on its website, so that the stakeholders like the direct foreign investors or those who are investing the money in the private public partnership should know that the act is not illusory, but it is taking shape and providing the relief to the parties who are approaching the commercial courts. The second aspect, so far as the Act is concerned, is about its jurisdiction. As I have already mentioned, that commercial court is another limb of the civil court. Basically, it's a civil court only, and the Commercial Courts Act 2015 is designed as a procedural law. But as the name suggests, and as the provisions of the Act also provides, it is confined, the commercial courts, as a matter of its jurisdiction, are confined to commercial disputes. They are not supposed to hear any other case than the commercial disputes, which are defined in section 2 within bracket C of the Commercial Courts Act 2015. Section 3 of the Act is regarding constitution of the commercial courts. Section 3(1)(a) is regarding pecuniary jurisdiction, which is a very important part of this Act. This says that the commercial suit which is to be filed before the commercial court, the value of the suit in no case can be less than ₹3 lakhs. This amount has been reduced in the Amendment Act of 2018. The upper limit has not been mentioned. The upper limit can be fixed by the state government with the consultation of the High Court. For example, as I have mentioned earlier, while talking about the overview, that some places, some session divisions, wherein there is a lot of commercial activities in the state of Punjab and Haryana, like Ludhiana and Gurgaon, which are considered to be the commercial hub of these two states. The pecuniary jurisdiction has been given to the ADJs and district and learned ADJs and learned district judges above ₹50 lakhs. Now, so far as the territorial jurisdiction is concerned, as I mentioned, that the commercial court below the level of the district judge is CJ as senior division, civil judge, additional civil judge, senior division, and junior division, division judge 5 years experience are designated as trial courts. District judge and ADJs are also designated as trial courts for the purpose of deciding the cases of particular pecuniary jurisdiction, and shall also work as the appellate court, that is the only appeal provided against the decision rendered by the courts working below them. As the data I have collected for the purpose of your information is that at present there are 176 commercial courts working in Punjab, 111 commercial courts working in Haryana, and there are 7 commercial courts in the Union Territory Chandigarh. Besides this, as per the roster of the Honorable High Court, there is 1 commercial division, single bench, and 2 commercial appellate division benches, out of which 1 honorable division bench has the pecuniary jurisdiction to decide cases up to decide and hear appeals up to rupees 500 crores, and the other honorable division bench as the pecuniary jurisdiction to decide appeals arising of the dispute of more than 500 crore rupees. Insofar as the jurisdiction part is concerned, there are two other significant sections in the statute, that is section 10, dealing with the arbitration matters. It provides that if the arbitration, if it is an international arbitration, then it shall be heard by the commercial division of the High Court. Otherwise, if it is a domestic arbitration, then the principal civil court, that is the Court of District Judge. Section 11 of the Act is a very interesting provision because it bars jurisdiction of the civil, it creates a bar also. Now, in section 11, it is provided that the commercial court can deal with the cases only which are dealt with by the civil courts, meaning thereby, if the jurisdiction of the civil court is impliedly and explicitly barred by any statute, then those matters cannot be brought even before the commercial court. For example, there are revenue courts, there are labor courts, where the suits dispute regarding of the civil rights are not being of the civil nature, which are being tried by the civil courts, are not being tried. So this is with regard to the jurisdiction of the courts. The third aspect of the Act is about the specified value. Section 2, subsection 1 of the Act defines it. And it says that it cannot be less than rupees 3 lakhs. As I've already mentioned, that 3 lakhs is the lowest limit of bringing a matter before the commercial court. Supposing somebody has a dispute which only involves rupees 2,95,000, then that kind of a suit cannot be tried by the commercial court. It has to be 3 lakhs and above. But the upper limit has not been provided, and it has been kept in the hands of the state government, which can fix the upper limit by way of issuance of a notification in the official gazette. Section 12 of the Act is regarding determination of the specified value, that how the specified value is to be determined. For example, now section 12 subsection 1 says that if the suit is for recovery of money, then how it is to be determined that the value of the suit is such that it would either fall within the jurisdiction of the learned junior judges, or it will fall within the jurisdiction of the learned senior judges like ADJs and learned district judges. The section 12(1) says that if it's a suit for recovery of money, then whatever money is sought to be recovered plus interest calculated up to date has to be seen just on the date of filing of the suit. Supposing the suit is prepared and it is kept in the drawer, and at that time the value is something else, and when it is filed, then the value is something else, then it is a matter of concern for the court. So the legislature has used the word till the date of filing and not till the date of preparation of the suit. The legislature has further provided different other circumstances for the purpose of determination of the specified value, like in a suit for movable property. It has how the value has to be determined. Similarly, in the matter of suit filed for immovable property, then how the value has to be determined. And in the suit in regard to the intangible rights, then how the value has to be assessed. It is every time it is to be determined first by the party and then, of course, by the learned commercial court. Besides the, now I have already mentioned in a sequence that what is the contours of the Commercial Courts Act. It is not an old act, unlike the CPC, which is more than 100 years old, in which every word of the CPC has been interpreted by the Honorable High Courts and the Honorable Supreme Court from time to time, and still there is so much scope of further interpretation. The Commercial Court Act came into being only in the year 2015 and has seen one amendment in 2018. So we are in 2022. Only 7 years have passed since the inception of this Commercial Courts Act in this country. According to me, though I couldn't see much of the case laws because the paucity of time at my end, there is not much law developed so far by the higher courts interpreting its various provisions. For example, the issue regarding the determination of the specified value, issue regarding the commercial dispute, whether a commercial dispute is a commercial dispute or not, whether it will fall within the territorial jurisdiction of a particular court or not. These are the gray areas which is to be addressed by the Honorable Higher Courts for the purpose of our guidance. Since it is a dedicated court, or I would say is a very fast track court, which has been conceived by the government, our parliamentarians have given consent, have prepared it and brought for our benefit. They have also defined as to what is the commercial dispute. Though the definition is not exhaustive, but still they have added 22 items in section 2C of the Act. If you go through these items, because one cannot remember all the items, so I will take little help from their Act. This says the commercial dispute shall be ordinary transactions of merchants, bankers, financiers, and traders, such as those relating to mercantile documents, including enforcement and interpretation of such documents. So ordinary transactions of merchants, anything which is being done by merchants, any kind of direct transaction which is more than ₹3 lakhs is then thus a commercial dispute if there is a dispute between the parties. Export or import of merchandise or services. Issues relating to admiralty and maritime law. Transactions relating to aircraft, aircraft engines, aircraft equipment, helicopters, including sales, leasing, financing of the same, carriage of goods, construction and infrastructure contracts, including tenders, agreements relating to immovable property used exclusively in trade or commerce, franchising agreements, distribution and licensing agreements, management and consultancy agreements, joint ventures agreements, shareholders agreements. You see the scope and the scope of the Act is so big. If we read this, what are the commercial disputes, that it will give a lot of great chances to the learned judges, especially of the courts below, for the purpose of their exposure. Then it says subscription and investment agreements pertaining to the services industry, including outsourcing services, financial services, mercantile agency and mercantile usage, partnership agreements, technology development agreements, intellectual property rights relating to registered and unregistered trademarks, copyright, patent, design, domain names, geographical indications, and semiconductor integrated circuits, agreement for sale of goods or provision of services, exploitation of oil and gas reserves or other natural resources, including electromagnetic spectrum, insurance and reinsurance, contract of agency relating to any of the above, and such other commercial disputes as may be notified by the central government. So clause 2C 22I further gives power to the central government to include any other kind of transaction, commercial transaction, as a commercial dispute to be tried and decided by the commercial courts. According to me, it's a very long list of commercial disputes which has been given in the statute, and an opportunity is given to the learned judges to decide these type of cases even at the very initial stages. You have been deciding these cases like declaratory suits, preemption suit, recovery suit, suit for specific performance, which is a very common suit now in the past 2 decades, injunction suits, etc. But deciding a commercial dispute, and that too without there being much guidance of the precedents before us, is a really big task before the learned judges. Be it may the learned civil judges or the learned additional and district judges. The last but most important part is the statutory remedy, that is statutory remedy of appeal. As I mentioned, that the appeal is provided under section 13 of the Act. Limitation to file an appeal is also provided, and limitation to decide the appeal is also provided. It is only one opportunity of appeal provided to the litigant, be it the plaintiff or the defendant. So the burden is much more on the honorable judges to be very, very careful in deciding the dispute of the parties, because it is not going to be corrected. Any decision taken by them is not going to be corrected by the higher court in second appeal. It is the final stage. The first appeal is the only appeal, and it is the final stage of such a dispute in which the specified value could be in crores of rupees. Then there is a provision in section 13, that is section 13(1)(a), which is regarding appeal against the order, which is appeal against the order, which is in consonance with Order 43 of the CPC. If you see section 43 of the CPC, the various provisions, various appeals have been provided. Generally, the appeals are filed against the decree when the civil suit is decided, that is under section 96 or 100. But there are certain orders which decides the rights of the parties in the suit. Therefore, the right of appeal is provided under section 104 of the CPC, and the procedure is and also under section 43 of the Order 43 of the Act. This is with regard to the return of the plaint, rejection of the plaint, Order 9 Rule 13 rejecting an application for setting aside an ex parte decree, etc. There is a long list of the orders which can be challenged by way of an appeal under the present statute, though there is no provision for any revision. Similarly, there is a provision for filing appeal under Section 37 of the Arbitration and Conciliation Act 1996. Now, Arbitration and Conciliation Act 1996, this Section 37, deals with the appeals like refusing to refer the parties to arbitration under Section 8, granting or refusing to grant any measures under Section 9, that is interim measures, setting aside or refusing to set aside an arbitral award under Section 34, that is the final award. So these are the provisions under which an appeal is provided under Section 37 of the Arbitration and Conciliation Act. Then there is a provision under Section 13, subsection 2, which says, and I may read for the purpose of explanation, that the appeals have to be filed only under the provisions of the Act, that is the Commercial Courts Act. This Section 13.2 starts with a non-obstante clause. This says, notwithstanding anything contained in any other law for the time being in force or latest patent of a High Court, no appeal shall lie from any order or decree or of a commercial division or commercial court otherwise than in accordance with the provisions of this Act. So the meaning of the non-obstante clause is that even if it is provided anywhere in any other court, any other law, or if it is provided even in the latest patent of the High Court, any appeal is provided, it will not work because the appeal has to be filed only under the provisions of the present Act, that is the Commercial Courts Act 2015. So these are the basic provisions on which I have spoken to you in regard to the working of the Act and as to why and the need of the Act. I may add here for the benefit of my dear friends, that in order to understand an Act, it is very important to read its aims and objects. The aims and objects of the Act give the complete picture of the Act if one can understand. Because any enactment which is brought by the legislature is in order to fulfill the need of the society. For example, when the Act of this Protection of Senior Citizens and Welfare of the Senior Citizens Act was enacted by the central government, it was felt that the time has come when the senior citizen, the property and person of the senior citizen should be protected, not only from the people from outside, but also from their own children if they are not serving them. That was the need of the society, that was the need of the hour, and therefore that Act was brought into being. So in this Act also has only one aim, and that to ensure the prospective investors in our country, in our various states, because our leaders, they go out, they reach out to the various investors overseas also, and showing them the prospects of good investment in our country. But in order to remove their doubts about the tardy process of litigation in this country, the act has been brought into it. So this is my views I have expressed. So I am really grateful to the Chandigarh Judicial Academy for granting me this opportunity to interact with you, and also to share whatever I have understood from the reading of this. Thank you very much.
Thank you so much, Justice Jain. You have articulated the very purpose as to why the commercial courts and the different aspects regarding jurisdiction and other various significant provisions of this particular act. We are indeed grateful to you for being once again with us. In fact, we had the first workshop on commercial courts in the year 2016, when Justice Bindal was the president of Chandigarh Judicial Academy as such. At that time also, you were the resource person. And once again, we have started and began with this particular first session through you only. We are grateful and looking forward to have you with us again sometime in some other program. Thank you so much.
Thank you very much.
Now the physical courts are starting. Please. Good morning. This second session is being devoted to amendments to the Code of Civil Procedure under the Commercial Courts Act of 2015. And for this particular session, we have with us this morning Justice Rajiv Ballah. He is a blend of a lawyer and a judge. Joined the bar in the year 1978 and continued till the year 2003. Thereafter, he was elevated in the year 2004 and retired in the year 2016. 25 years as a lawyer and 12 years as a judge. What a blend, what a mix of experience, both of the bar and the bench. And after retirement, after heading the tribunal, Punjab Education Tribunal, he is once again in the domain of a lawyer. He is contributing immensely in this particular process, and particularly the Civil Procedure Code in relation to the Commercial Courts Act. The kind of changes which have been made is actually the domain of Justice Rajiv Ballah. And therefore, we thought it appropriate to have Justice Rajiv Ballah for this particular session. To my mind, no one else could do justice to a topic of this magnitude. I'm conscious of the fact that the topic is so vast, and to capsule it in 1 hour is not an easy exercise. But knowing the skills of Justice Ballah, I'm sure he would really make this particular session a hugely contributory session. Over to Justice Ballah, please.
Good morning, sir. And before I start, as usual, I'll pay respect to my teacher, Dr. Balram Gupta. He taught me in the law college. Then he became a lawyer, a senior advocate, and now he's the director of the academy. So I have many memories and many connections with him. Now, thank you, sir, for having me here, and good morning to everybody. Once again, thank you for the kind words, totally undeserved praise. But I'll straight away dive into this topic, which I, like rightly said, in 1 hour, I don't know whether I'll be able to even do it. So I plan to just rush through it to give you a bird's eye view, because some of you may be doing commercial courts and some of you may not. But I think eventually everybody will get a chance to head a commercial court or do some work. So the Commercial Courts Act 2015, and which has been amended twice, thrice again, brought certain significant amendments into this monolithic code called the Civil Procedure Code, which I think you'll all agree with me is totally out of step with today's demand for speedy justice. Schooled as we all are and shackled as we are by the rules of procedure, more often than not, justice gets sacrificed at the altar of procedure. This act is maybe one attempt to unshackle justice, but unfortunately only for commercial disputes. I've been asking this question, why only for commercial disputes? Why can't this procedure be extended to all civil disputes? But as usual, Parliament will take its own sweet time, maybe another 20 years before it decides to amend the CPC. So now I take you straight away to the provisions of this Act. You may be familiar with it, and I'm quite sure all of you will be. But Section 2E defines commercial disputes in an inclusive definition from Roman 1 to Roman 22. It includes all sorts of disputes. In fact, I find very little disputes that are left out. Even your agreement to sell, your lease deeds, which are not covered by the Rent Act, everything is covered here. And there's two very important explanations. I will not go through this because of lack of time. There are two important explanations. Explanation A, that even if the dispute involves recovery of immovable property, it will not be prohibited as a commercial dispute. As an example, suppose there's a lease and the lease involves recovery of immovable property. It will go to a commercial court. And merely because it is an immovable property, it will not be prohibited. But yes, what will be prohibited is if it is covered by the Rent Act. Two, if the state or an authority which discharges public functions is a defendant in these proceedings, it will not be prohibited. The state, there can't be any defense that the state is a party, therefore this is prohibited. So a commercial dispute, I please request you to just go through 2E 1 to 22. So now I'll quickly start moving towards the amendments. Section 2F is again an interesting amendment which defines the word document. Why I'm talking about document is because most of the disputes that come to commercial courts arise from contracts, some way or the other, whether it's an agreement to sell, or it's a contract for lease, or it's a franchise agreement, or it's whatever type of agreement, it will come here. But yes, disputes which do not have any commercial element will be excluded. You may be called upon to determine that at a particular stage. So please be very conscious of reading these sections and the definition of document. Sorry for paucity of time, I can't go through the definitions. But then there's another very important provision which has come in lately. That's Section 12A. Section 12A makes it mandatory for pre-institution mediation. Now, pre-institution mediation, you can all understand, it's a very simple word, that before you file a suit, you must go in for mediation. But the issue here is, what happens when there is no pre-institution mediation? The section somehow seems to be silent or a little vague on that. So there has to be pre-institution mediation. But another exception, if there is an interim relief which is urgent in nature, then you can do away with this mediation process. As it is, most of you refer people to mediation. So that's the part of the mediation. I can't go through too much. Now, the amendments, let's quickly rush through the amendments. Form of pleadings. Order 1, parties to the suit remains the same. Order 2, frame of suit remains the same. Order 3, agents and pleaders remains the same. Order 4, institution of suits by plaintiff remains the same. The first amendment that comes in is Order 5. And that's the most important one, which comes repeatedly. It says when a person fails to file a written statement within 30 days, he can be allowed a maximum time of 120 days. That also after the officer concerned records reasons for allowing such time. And if after 120 days he still does not file a written statement, no further time can be granted. There's another provision that comes in later, which I'll refer to. So therefore, the defendant forfeits his right to file a written statement, and the court shall not allow him to do so. So I hope that is very clear. You'll have to use the word forfeits his right to file a written statement. Now, you're all aware that pleadings are contained in Order 6. So 3A says that pleadings where there are High Court rules and orders shall be filed in accordance with the High Court rules and orders prescribed in the rules, such rules as may be framed. But rest of the provisions remain the same. Then we come to Order 6. Order 6 contains a very interesting amendment, 15A. I can just read it out. Verification: when somebody comes to you with a commercial suit, please check his verification. And I can just read that part out to you. Just a minute. You may have read it, you can read it, but since I find it rather interesting, I think I should read it out to you. Notwithstanding anything contained in Rule 15, that's the rule. Every pleading in a commercial court shall be verified by an affidavit in the manner and form prescribed in the appendix to this schedule. An affidavit under Sub-Rule 1 shall be signed by the party or by one of the parties of the proceedings or by any other person on behalf of such party or parties who is proved to be satisfactorily to be acquainted with the facts. Where a pleading is amended, now let me take you to the appendix. All right. Let me just take you to the appendix, and you can read it. We needn't waste too much time, but please be very clear. There's a slight difference in the verification. Now we come to the plaint, because that's more important. 2A seeks to modify the provision regarding interest. That's Order 7. The rest of it remains the same. So please be very careful. Where the party has claimed interest, you will have to ensure that, I'll just give you the particulars, that it prescribes the rate, the date from which it is claimed, and the total amount calculated, the daily rate, etc. Please read it in detail. It's very different from the normal CPC rate of interest which you claimed at 18% per annum. That's all. Here you will have to go and make a specific reference to the rate of interest. And if he doesn't make it, it's up to you now to figure out what to do. So this is Order 7, Rule 2A, which is added there. Then rest of it remains the same. Now Order 8 is written statement, set off and counterclaim. Rule 1 is the same. That 120 days final time again comes here. Rule 3A. I'm reading Rule 3A, which has been added, which is very important for the courts as well as for the defendant. So I'm just reading that to you. I'll read Sub-Rule 2. The defendant in his written statement shall state which of the allegations in the particulars of the plaint he denies. He must specifically say which does he deny, which allegation he is unable to admit or deny, which allegation he is unable to admit or deny, but which he requires the plaintiff to prove. This is a little tricky provision. Allegation he is unable to admit or deny and requires the plaintiff to prove, and which allegation he admits. These three things you have to ensure in the plaint, that in the written statement, that an averment to that effect is made. The idea behind this amendment is to shorten the procedure of proof of documents, etc., which I'll come to later. You all are aware of the fact that almost in every pleading in the written statement, it says para so-and-so is denied being false and incorrect, and then says, because I have no knowledge about this document. But he must now specifically refer to why he has signed a document. Why is he denying the document? Is he alleging fraud? Is he alleging undue influence? Is he denying his signatures? there must be a specific denial. And if he is unable to admit or deny, then he must say so, why he is unable to admit or deny, and that he requires the plaintiff to prove these facts. If he is going to make an admission, the admission then must be specific. So this is something important. Normally in the plaint, you say there must be clear pleadings, etc. by specific denial, but these words have been added. Then there's subclause 3 of this subrule, where the defendant denies an allegation of fact in a plaint, he must state his reasons for doing so, which I was just telling you. And if he intends to put forward a different version of events from that given by the plaintiff, he must state his own version. Now, this is a departure so as to ensure that most of the pleadings which are in the plaint are admitted or denied, or a request is made for the plaintiff to prove them, and then only with the question of admission and denial come in, or a document being read against the defendant become an issue for the court to decide. So if he denies an allegation of fact, he must state his reasons for doing so. So this makes it even tighter, even more. And if he disputes the jurisdiction of the court, he must state the reasons for doing so. We normally have clauses, say preliminary objection, the suit, the court is barred from entertaining the suit as it is barred by limitation. You know, section 3 requires you to throw out a suit even at the outset if it is barred by limitation. But he must make specific facts. Why is it barred by limitation? And similarly, it says you'll always find a paragraph, normally number 2 or 3 in the preliminary objection, that the court does not have any jurisdiction. If he says so, he must raise a specific plea of lack of jurisdiction of the court, of the prohibition of jurisdiction of the court to entertain the plaint. A general omnibus denial can be validly ignored by the court. You do it also, but we have all come across, and you also know, the court still goes and frames issues many times. So please be careful, look at these, use these provisions, and don't think that they are just meaningless provisions, and do not even think that they are all similar to the CPC. There's a huge difference. And then we come to Rule 3A. Just take out Rule 3A. No, it's there. It's there in the book. Come to Rule 3A, I've read. Then there's a proviso. If you remember, Rule 5 says specific denial. Now this specific denial will be replaced by these rules. And then there's a proviso to Rule 5, which says provided further that every allegation of fact in the plaint, if not denied in the manner provided in 3A of this order, this is very important, the one I was just reading to you, shall be taken to be admitted except as against a person under disability. So those conditions I read to you, that subrules 2, 3 and 4 of Rule 3A, if not denied in the manner stated in these subrules, it will be deemed, provided subrules, it shall be taken to be admitted, except as against a person with disability. There's another provision which I just forgot to point out, that's 3A5, that relates to the valuation of the suit. And that also can't be without reasons. Normally you say the suit is not valued correctly. So you must give a reason why it is not valued correctly. So this is a very, very important provision. And it's a provision that would enable the court, if implemented properly, to speed up the process of justice in commercial suits. Now the question comes, why commercial suits only? Well, because in commercial suits, a lot of money gets tied up. And you're all aware that a country or even a people, it's the economics that is important to today's times. And since we tend to move towards a capitalist economy, there is something known as the ease of doing business. And in order to achieve those ratings, all these provisions have been amended so as to that ease of doing business. Now, if you have a suit for eviction on the basis of a lease deed, which is not covered by the Rent Act, you will file a suit for possession under the Commercial Courts Act, read with the CPC. And if you plead in this manner, it becomes much easier. I'm putting it from the angle of a lawyer, because though you are all judges, you will examine it from the angle of a lawyer, that has he pleaded all these things. So you must understand what a lawyer is required to plead and not just what a judge is required to decide. Because till you don't understand what a lawyer is required to plead, it's you do not understand the essence of a provision or the essence of a right. So please understand, if the lawyer does not plead this, then you will ask him the question that why should I not that same procedure, that since you've not pleaded this, I'll take this as an adverse inference against you. Now we come, I'm sorry, there is actually this topic in itself. I request Dr. Balram Gupta to have separate small modules for this act, because though this is something we all know as lawyers and judges, that denials, etc., should be specific, but we've never had a provision which is prohibitory in nature, which says if you don't do this, then finished. The whole suit will finish if you don't do it, if your denial is not this. Now we come to again that same proviso that prohibits the court from extending limitation at all beyond 120 days as far as the written statement is concerned. Then we come to Order 9, which remains unchanged. We come to Order 10, which again remains unchanged. Then we come to discovery and inspection. Discovery and inspection under Rule 11 is totally different from what is in the CPC. Please, I cannot take you through this entire voluminous document, but please read this entire document. This, I say document because it's rather long. So Rule 11. Now, what is interesting in this is that now, earlier we always file documents with the plaint. Okay. These are now codified in sub rules 1 to 16. 1 to 6, sorry. And the written statement or counterclaim in 7. I'll just briefly refer to you what documents have to be disclosure and discovery of documents. Plaintiff shall file a list of documents and photocopies of all documents in his power, possession, control, or custody pertaining to the suit along with the plaint, including documents referred to, relied on by the plaintiff in the plaint, etc., etc. Nothing in the rule shall apply to documents proved to the plaintiff and relevant only for cross-examination. Then it goes on and on and on. Then it's settled. Then 7 is the defendant shall file. Similarly, it goes up to the defendant and also in his counterclaim. And then it makes its rather long. Then it refers to electronic records. So everything is there, inspection, discovery, how to go about it. The entire chapter on disclosure, discovery, inspection of documents is in Rule 11. So anybody interested, as far as I know, not too many of our judges in Punjab and Haryana use this procedure, but I find this is used very often in Delhi, and it's a brilliant procedure to cut down the entire matter. The only thing is that you'll have to control it. What happens is lawyers have a habit of saying that this document is denied, but they do not refer to why this document is denied. So even when you come to the admission and denial portion, this is something you will have to look at. You cannot possibly just allow the lawyer to lead you by the nose. You have to have control of the proceedings. So this is a provision. Please, I request all of you to also study when the plaintiff is filed, that please examine, or the written statement is filed. And then it also has about the electronic records, etc. The entire thing is there. So this is a very important detailed provision this time. And we normally had these provisions, but now they've gone into greater degrees of detail. Then we come to order. Admissions remains the same, order 12, order 13, and then we come to order 13A. If you are going to be in a commercial court, you will have to acquaint yourself with the original procedure of summary judgments in the CPC, of rendering summary judgments. But thereafter, you'll have to read 13A, order 13A, which is call it the heart or the heartbeat of the Commercial Courts Act. And it also permits you to pronounce a judgment without oral evidence, also permits you to record oral evidence. But then at every stage, you will be under Rule 2. It gives you the stage of summary judgment and how it is to be applied. It's slightly different from the original procedure, and grounds for summary judgment, then the procedure for summary judgment, and then we come to orders. You can pass a conditional order, you can pass a judgment, you can dismiss the application, you can dismiss part of the claim and a judgment or a part of the claim. You can strike out the pleadings, you can issue further directions to proceed. Whether the court makes an orders, as in somewhere, the court shall record its reasons for making such orders. So, though it's already there, but this makes it better. Then it goes on to define what are conditional orders and then power to impose costs. So this is basically of summary judgment. And there's something very interesting in this. Then I'll just take you straight away to order 28. Just turn to order 28. This provides as to how written arguments are to be filed. Rule, I'll just read out. I'm sorry, it's 18, not 28, my mistake. Sometimes I also get confused with this Roman numerals. Order 28. Written arguments, rule 4. Just take it out. Just excuse me, I'm running a little cold. Rule 4. 1 minute. Just a minute. Rule 4 allows you, sub-rule 4 of this, may by direction regulate the evidence as to issues on which it requires evidence and the manner in which such evidence may be placed before the court. And then it says redacting or rejecting evidence and format and guidelines of evidence is rule 6. An affidavit must comply with the form and requirements set forth below. What we do normally in courts is an evidence is a repetition of the pleadings in the plaint or the written statement and nothing more. Here, the affidavit is very, very different. It should be confined to and should follow the chronological sequence of the dates and events and that are relevant for proving any fact or any other matter dealt with. Where the court is of the view that an affidavit is a mere reproduction of the pleadings or contains the legal grounds of the party's case, the court may by order strike out the affidavit or such parts of the affidavit as it deems fit and proper. This is Subrule 6B. Each paragraph on average should, as far as possible, be confined to a distinct portion of the subject. An affidavit shall state which of the statements are made from the deponent's own knowledge. That is the question of verification. So now under the Commercial Courts Act, you will have to regulate the filing of the affidavit. And in case the affidavit is not filed in accordance with Rule 4, the format and guidelines of affidavit evidence, you can suggest to the person that please amend your affidavit or change your affidavit, subject however to the defendant screaming and shouting that he can't do it. So you are in control of the entire proceedings. It's not as if you are standing there as a silent spectator and allowing the lawyers to do whatever they want to. Now, a small request to all of you that it's not as if you are sitting there as an umpire or somebody who's just standing by. This act now empowers you. In fact, the original CPC also empowered you, but lots of us allow lawyers to run the entire show. You must, in my opinion, if you want to render this procedure relevant and not render it another piece of the CPC, as has happened to all other amendments, you must implement this. Now, there's another important, very, very important provision which grants you 90 days to pronounce judgment. Just take that out. And before that, we have 19. I'll just take it to 19. It's in the old act, in the act itself. So, you have 90 days to pronounce judgment. Take it from here, just take it from here. And there is something new this act has put in, statement of truth, called statement of truth. I don't know how far you will be able to implement it, but in Appendix 1, there's under first schedule order 6 Rule 15A, order so and so. The deponent do hereby solemnly affirm and declare as under, there is a statement of truth to be given. And this statement of truth is more or less something like the original the verification, but this time it's in the shape of a separate affidavit, and which, if not found to be incorrect, you can always dismiss the suit on this account for filing a false statement of So basically, I've just taken you quickly through these amendments, which broadly speaking will fall into these broad formats, and there's nothing that is so scary about this act. It's just a procedure that quickens up everything. Now, in my opinion, each one of these amendments, or maybe one or two together, like you can have the pleadings together, the form of evidence together, the provision for how and in what manner summary judgment, because it's very different from the old summary judgments, would require, if at all anybody so likes, a complete separate discussion. And apart from all this, this includes a mandatory case management system, which was also there earlier, which the High Courts had implemented, but now it's part of the Act itself. In Section 6 of the Act, and this is prior to framing of issues, hear and decide any pending application filed by the parties under Order 13A. Direct parties to file compilations of documents or pleadings relevant and necessary for framing issues. You can even at that stage call for all this. Extend or shorten the time for compliance with any practice, direction or court order if it finds sufficient reason to do so. You can shorten the time for compliance. You can extend the time for compliance. Adjourn or bring forward a hearing if it finds sufficient reason to do so. In brackets in all these provisions read for reasons to be assigned, those not said so. Direct a party to attend the court for purpose of examination under Order 2, Rule 9. Consolidate proceedings. Strike off the name of any witness or evidence that it deems irrelevant. Direct a separate trial of any issue. Decide the order in which issues are to be tried. Exclude an issue from consideration. Dismiss or give judgment on a claim after a decision on a primary issue. Direct the evidence be recorded by a commission where necessary in accordance with Order so and so. Reject any affidavit or evidence filed by the parties for containing irrelevant, inadmissible, or argumentative material. This is an extension of what I just told you about that rule. Strike off any parts of the affidavit or evidence filed by the parties containing irrelevant, inadmissible, and argumentative material. Delegate the recording of evidence to such authority appointed by the court. Pass any order relating to monitoring. Order any party to file, exchange a cost budget. Issue directions to pass an order for the purpose of managing the case and furthering the overriding objective of ensuring the efficient disposal of the suit. When a court passes an order in exercise which passes under this order, it may make it subject to conditions, including a condition to pay money into a court and specify the consequences of failure to comply with the order. While fixing a date for case management hearing, the court may direct that the parties also be present for such case management hearing, if in its view there is a possibility of a settlement. The court shall then, the next one, shall not adjourn the case management hearing for the sole reason that the advocate appearing on behalf of a party is not present. Provided that an adjournment of the hearing is sought in advance by moving an application, then it can. Now, this case management is something that will enable a commercial court to not only fortify the provisions of the commercial court amendments, but also itself. Because there's another provision which says consequences of non-compliance with orders, where any party fails to comply with order of a court passed in a case management hearing, the court shall have the power to condone, foreclose, dismiss. All these things are there. So it's not a case where they have just shifted commercial courts from ordinary courts to a commercial court. The entire method of working, the entire method of consideration has changed perceptibly. So I think my request to the Academy is that this is a thoroughly inadequate session as far as I'm concerned, and I know the paucity of time. So I'll once again request the director that this entire part, you may have already heard it, should be made into separate modules. Case management, a separate module. Discovery, inspection, and documents, a separate module. Mr. Gupta, I'm sorry addressing you directly, but all these things are very important. Very important because soon we'll have many of our commercial courts floundering, because in Punjab and Haryana, the High Court does not have original jurisdiction. In Delhi, I would like to inform you, the High Court is exercising these bars. because it has original jurisdiction. So things are slightly different in Delhi and different here. And another small request that the rules framed by the High Court under this Act may also be, I think all judges who are dealing with these cases are not even dealing, should be provided a copy with the rules also, because any day they are going to be concerned with this. I think with that, this brief, call it just a flight from Chandigarh to Delhi of 45 minutes is now over, because if I say anything more, then I'll encroach upon Justice Pratibha Singh's lecture, I think, which she must be waiting for. So I think that's all I have to say. And if anybody has any questions, sir, please ask them to send it to the Academy. I'll be only glad to answer those questions, even by mail or anything you feel.
Thank you so much, Justice Ballah. See, I totally accept the suggestions made by you. This time capsule was absolutely inadequate in order to cover effectively the session as such. I'm one with you, and the suggestion further which you have given certainly would be taken care, and we would look forward to that as such. In fact, right in the beginning of this session, Justice Ballah focused on this aspect, that these amendments in the Civil Procedure Code, why only the commercial courts? Why not other courts also to follow this particular procedure as such? Because the ultimate object is speedier, effective adjudication of the commercial disputes. And this particular parameter or a barometer is equally applicable to the other jurisdictions as well. And therefore, this particular suggestion is very well taken up, and we look forward as to what we can do in this particular context. We would certainly look forward to that. And finally, the offer which Justice Ballah has made, that those participants, judicial officers, who have any particular queries, questions relating to this aspect, can refer those particular queries to the Academy, and we would share those queries with Justice Ballah, and so that we could take care of the issues and problems which confront particularly the judges who are manning the commercial courts in the district level as such. Justice Ballah, so very kind of you. You are always very generous, magnanimous with us. Your contribution to Chandigarh Judicial Academy is immense. And this association with the Academy, we keenly look forward to continue as such. Grateful to you, sir, and
Thank you,
look forward.
sir. Can I now switch off?
Thank you so much. That's very kind of you.
That's all we've learned in the 2 years of COVID.
That's right. That's right. Thank you so much.
Okay, sir. Thank you very much. Bye bye, and thank you for having me. And thank you everybody for patiently listening to me. But this is totally inadequate. Thank you. Thank you, sir.
Thank you.
Good morning.
Good morning. Good morning to you.
Can you hear me?
Good morning. In this third session of this workshop on commercial courts, we have with us Honorable Justice Prathama M. Singh. A great pleasure and I deem it an honor to introduce Justice Prathama M. Singh. Throughout her journey as a student, as a lawyer, and as a judge, excellence Am I audible?
Yes.
Yes, please. You know, your journey throughout has been excellent as such. Joined the bar in the year 1991, was designated as senior advocate in the year 2013, and elevated as Judge Delhi High Court in the year 2017. Scholar and scholarship have been the insignia of Justice Singh for that matter. She is a decorated soldier of the legal fraternity and a judicial laureate in the domain of intellectual property rights. And therefore, this morning, this specific important area of intellectual property, disputes relating to trademarks and designs, and equally the disputes relating to copyright and patent, would be the coverage of this particular session by Justice Singh. I have great pleasure in presenting to you all Justice Singh. May I request you to kindly start with the session.
Thank you so much, Dr. Gupta, for your kind introduction. A very good morning. Before I start my session, I wanted to know a couple of things.
Yes.
The audience consists of, how is this being beamed to the audience?
Through the YouTube, please.
Okay. And this is for commercial court judges or for all of them?
See, this is for all additional district judges of the state of Punjab and Haryana.
Okay.
And those who are presently also holding the commercial courts. And we have also opened this particular session, and the entire workshop for that matter, to all the officers of different judicial academies across the country.
Okay, thank you so much. Thank you so much. Okay, I will be, before I start my presentation, so this is for 1 hour, isn't it, Dr. Gupta?
That's right, that's right.
Okay. So we won't be able to take any questions because it's a unilateral thing.
I mean, I wish it could be done, but that's probably not possible.
Okay, perfect. So a very good morning to all viewers and to all the judicial officers who are watching this program today. It is my distinct pleasure to address all of you under the aegis of the Chandigarh Judicial Academy. Dr. Balram Gupta has been very kind, and I accepted his invitation to speak to all about intellectual property and what are the latest developments. I can tell you one thing, that 1 hour is too little a time to speak fully about intellectual property, but we'll try and cover as much as we can. And what I would comment to all of you is to, after getting a bird's eye view, maybe look up some of the judgments, etc., which I will be mentioning in my presentation, some of the latest ones. So I'm going to cover a large domain, but I think the last few slides will be very important owing to some very recent developments that have taken place in India. with the abolition of the Intellectual Property Appellate Board, which is by the Tribunal Reforms Act of 2021, the IPAB has been abolished. And because of that, the manner in which intellectual property cases are now going to be dealt with across the country is going to be changing. And I would like to highlight to you all what is the latest development in Delhi High Court in this regard, so that this can be kind of a guidance and look for something for all of you to look up to in terms of how to manage the new kinds of litigation that are going to be coming before you all. So I'm going to I would like to share my PowerPoint presentation. So I'm not sure how to do that. So is there anyone, Shivam, can you help me with it? No. So what do we do here?
This one.
No, that shares
Share tray.
No. Share tray is what required?
That.
Okay.
This is
Without a PowerPoint presentation, this will be difficult. So just let me figure it out in a minute.
it's
Sorry?
you can go right through this one, open your Teams now.
No, it's already there. No, I'm already there.
Just
Dr. Gupta, do you have someone there who can tell you how to share screen? Because in Teams, I haven't done it before.
Just a moment, I would kindly.
I'm used to doing it on Cisco and on Zoom, but I haven't done it on Teams before.
Why say?
Where is our PPT? Yeah, this one.
This one is can you just stop spotlight me do it once.
No. All right. While we are going to sort this out, I will start by saying, as you're all aware, intellectual property and IPR as such, everyone is always under the impression that it is a kind of very complex litigation. Why should we all be doing it? Because there are very few cases. So my first message to all of you is that intellectual property is a subject which is very close to everybody's daily life, whether it's the newspapers that we read in the morning, whether it's the television that we watch, the books that we read, the telephones that we use, the automobiles that we drive, almost everything is based on intellectual property. There is not a single thing that can be done without creativity and innovation. And the first message, therefore, I would like to give all of you is that intellectual property is important for us, not merely because we are lawyers or judges, but because it is part of everyday human everyday life. And we should stop thinking of it as a very complex subject matter or very complicated, which we cannot understand or anything like that. We should be open in in the manner in which we take up intellectual property cases and decide them and decide the issues that arise in them. The foremost thing I would like to say is, as you all know, there are various forms of intellectual property, whether it is trademarks, copyrights, patents, designs, geographical indications, plant varieties, or any such form of intellectual property. Some of these are protected under statute and some of them are protected under common law. We also have what is called trade secrets, which are protected under common law. The principles of trademarks and copyrights and these related rights are all very well settled and well established. India has had a very long jurisprudence in this
just a
field.
moment.
Yes.
It has to be linked from your side. My technical person is here to assist.
Good morning, Your Lordship.
Yes.
If we go upstairs, if we go see the upper form, it is camera, mic, and then it is share. Camera, mic, and share. So
Yes.
if you click the share,
Yes.
then it will come a screen. You have to share your screen. Click the screen share. Camera, mic, share, then screen share.
It's not coming on my thing.
Ma'am, do we have any technical person there with you so that I can help him?
Ma'am, usually it's share content, but now it's showing close share tray. So it's showing a share tray. Usually in Teams, it's share content.
Yeah,
Right.
it's either shared content. Yes, we are able to see it from here. What issue is coming up there?
In this, it's showing share tray instead of share content.
Okay. Let me check that then. Let me check that. Okay. Thank you, ma'am. Ma'am, let me check that and then I'll see what I can do about it.
Okay. Right. So as we move forward, the kind of intellectual properties that are there, as I've already mentioned to you, there are statutorily, we have about 5 or 6 intellectual properties, 6 to be precise. The remaining 7 to be precise. The remaining forms of IPR are all non-statutory intellectual property. What is the importance of the value of intellectual property? Let us understand that first to be able to appreciate the importance of it. Let us take, for example, an iPhone. The manufacturing cost of an iPhone is approximately maybe $250 to $300, and the actual manufacturer earns about $8 to $10 every year for every device. But the retail price could be much above $900 to $1,000. So while the components and the manufacturing cost could be less than $300, the sale price is about $1,000, which is more than 3.5 times. So the entire remaining value, apart from the value of the components, etc., is the value of the intellectual property. The value for intellectual property, therefore, is much, much more than the value for the raw materials, the components, the manufacturing cost, and all that. Why is it so? Because to be able to put all those components together and to make them function in a particular manner, there is a lot of research and innovation that is required. Without that, it is not possible for anyone to be using an iPhone with all the features that it has. It requires enormous amount of innovation, enormous amount of research, long hours of engineers who put in a lot of work, and only then they're able to come up with such kind of products. Yes, please. Okay, can you see the screen now?
Yes, that is absolutely visible.
Okay, so now give it to me. So these are my slides to show you how intellectual property is a part of daily life, whether it is starting with the way we brush our teeth or we use newspapers. There are various intellectual properties that are involved in all this. And I believe that the way we live is only with intellectual property all around us. Please see as you go by how everything that we use on a daily basis has intellectual property in it. Whether it's brands, whether it's designs, whether it is trademarks, whether it is logos, every day there's there is copyright in applications, the clothes we wear, everywhere there is intellectual property, there is designing, there is logos, there is marks, there is geographical indications. For example, Pashmina shawl, Kanjivaram saris, these are all protected in intellectual property. Whether it's the food we eat, food has patents, it has trademarks, copyrights, trade dress, designs, copyright in recipe books, plant varieties, various varieties of seeds which are sown in the country by farmers. So there's hardly anything that we do in our daily life which does not have intellectual property. The patents in the car, automobile engines, artistic works and logos, the music that we listen to when we are driving to work, there is copyright in musical works. There is a whole jurisprudence of compulsory licensing in this. The computers that we use, copyright in the software programs, television channels. We today watch Netflix, Amazon, everything as we, end our day. These are the books that we read. There is copyright in books. So that's the message I want to give, that IPR permeates our daily life. And there is not much of life that is there without IPR. And this is something we don't realize unless and until we start thinking in this way. So going back to intellectual property, 1883 is when the first convention on industrial property was started in the world. And that has moved from 1883, 1891, 1967, the Patent Cooperation Treaty in 1970, the WIPO being established, and finally the TRIPS agreement. Now, I'm not going to go into these details because it can take a long presentation. The three basic principles of these treaties and conventions is that there is a principle of national treatment, meaning thereby we treat foreign IP owners and Indian IP owners on the same platform. We do not discriminate between foreign and Indian IP owners. There is automatic protection for most of the intellectual property protected works. For example, we, under the law of passing off, we can protect foreign trademarks. Copyright need not be registered in any country. It can be protected without registration. So suppose there is a movie made in India, if there is a pirated copy being sold in Canada, in America, in Europe, the copyright owner can take immediate action without a registration. The principle of independence of protection is that the work is independent of the country from where it has been created. So therefore, these are very basic jurisprudential principles in intellectual property. And if we go forward, I would say that the TRIPS agreement of 1995 completely changed the way in which the world looks at intellectual property. The principles of IPR now are uniform across the world. And these are the various types of IPR which I just mentioned. Okay, one very big important objection which normally you hear in conversations is that, patents are no good. The foreigners take away haldi, they take away neem. This kind of miscommunication exists. So I want to state that, while there were patent applications filed in Europe and America for preparations made from neem and turmeric, the Indian CSIR was able to oppose these patents, place the documents relating to traditional knowledge in these patent offices. In fact, these patents were not granted by those countries. And this led to the creation of what is called the Traditional Knowledge Digital Library, TKDL, which has now digitized millions and millions and millions of, you can call them materials, scriptures, all kinds of traditional material which was available in India on our various medicinal practices, etc., which helped us in creating this library. And this library has now been shared across all patent offices in the world to be able to oppose any grant of patents to traditional knowledge. Now, there are lakhs of trademarks which are filed every year. I think as per the recent figures, the number of trademarks which are filed have crossed more than 4 to 5 lakhs. And it is a huge number. And 80% of the trademarks which are registered are belonging to Indian businesses and Indian IP owners, which is a big thing because it just shows that within India, our businesses, our traders, everybody is very, very conscious of their trademark rights. Now, let us look at the broad framework for protecting intellectual property. The first framework, of course, is legislature. They are the ones who enact the various statutes. We have the administrative machinery, which involves like the trademark office, the patent office, the copyright office. They're all now under the Controller General of Patents and Trademarks. We have the departments in the government, like the police, customs, drug authorities, etc., who take care of various aspects of intellectual property. And of course, the judiciary. And after the Commercial Courts Act has come, the judiciary is playing a very important role in protecting intellectual property. We have the commercial courts at the district level. Then we have the commercial divisions in the High Court, and then the commercial appellate divisions at the division bench. So these is the three-tier mechanism. And finally, of course, the Supreme Court, if and when the matters are reached, are taken there. So the three-tier system is the basic system that operates in intellectual property. In the judiciary at the commercial court level, all the civil litigation is filed. The criminal litigation relating to offences of trademarks and copyrights, patents, there is no criminal offence. Infringement is not a criminal offence of a patent. But for trademarks and copyrights, there is infringement, which can be, it can be an offence also to do a false representation of a trademark. So the criminal and the civil courts primarily handle the intellectual property cases, but 95% is mostly in the civil courts, i.e. the commercial courts. Now, everyone knows what a trademark is. I think I'm going to skip this. What are the various principles which have been laid down by, the judicial interpretations? There is the principle of trans-border reputation, which is very important because a large number of foreign trademarks were being registered by Indian companies without the permission of the trademark owner. And it was felt that there needs to be a proper system which is evolved wherein well-known foreign trademarks are protected in India. So there is this entire jurisprudence about trans-border reputation, well-known trademarks. Let us look at, for example, infringement in respect of dissimilar goods. Suppose someone uses the trademark Philips, which is used for electronic goods, for, let us say, a bed mattress or for a pressure cooker. Should we allow it? No. There are judgments which say so. The Mercedes-Benz judgment, which deals with dilution, is one of the most well-known judgments. Benz is, of course, used for luxury cars, but when it was used on undergarments, the court said, no, we cannot permit this. Then there is the entire jurisprudence relating to comparative advertising. As you've seen, the Surf and the, Procter Gamble, Rin and Surf and Dettol, these are the Colgate and the Pepsodent. There are all these comparative advertising trade, cases which have developed a large amount of jurisprudence. Basically, these judgments hold that it is not permissible for anyone to, compare a product and say that product is bad, my product is good. While you can say your product is good, you cannot disparage or defame the other person's trademark or product. So this is the jurisprudence of comparative advertising. Then, of course, there is parallel importation, where there's a new level of jurisprudence wherein suppose second-hand goods are brought into India. This happened in the case of Samsung. Samsung photocopiers were being brought into the country from, these were genuine products, but what was happening was the Samsung company said that these are not meant for being sold in India. And these are second-hand products. We cannot give warranty, and therefore these should not be sold. So the court, the division bench of Delhi High Court, held that you cannot stop genuine product from being brought into the country. But what can be done is that the product, the person who's importing it has to make sure that when he is selling it, he tells the customer that this is a second-hand product, we do not give warranties to it, and he should not in any manner use the trademark so as to make the customer feel that this is a genuine first-hand product. So long as they don't do that, parallel importation is permissible. So there are several judgments of the Supreme Court and High Courts on trademarks. I mean, this is one of the most well-known judgment of the Supreme Court on passing off. In fact, this is a judgment of Justice Sikri, who is going to be speaking now, I think, in the next session to you all. This is a judgment called Syed Mohinuddin versus Sulochana Bai. There was a Tamil Nadu trademark in Tamil Nadu called Irittu Kadai, and this was a specific halwa which was being made, and someone else started using Irittu Kadai halwa, and the defendant opened what is called Tirunelveli Irittu Kadai halwa. So the Supreme Court said that the right given by registration are always subject to the rights of the prior user. The prior user is superior to that of registration, and just because the defendant has a registration, he cannot copy the mark of an earlier user which has a reputation, and the court held in favor of the plaintiff. There was another case called Darzi for a tailor. So the court said that even in this case, Darzi, though being an Urdu word, is not a usual word for a tailor, and the manner in which the defendant used it would make it confusing, and therefore the injunction was granted. This was another Supreme Court judgment, Prius Auto versus Toyota. In this, the trademark was Prius, which is used for a hybrid car, and Prius Auto was a Karolbag-based automotive dealer who was calling it Prius Auto Parts. So when the plaintiff filed a suit, the court analyzed and said that Prius is a dictionary word, and when the defendant adopted the mark in April 2001, the Toyota's mark was not known in India, and therefore the Supreme Court held in favor of the defendant and held that every foreign mark cannot be protected in India. It has to be shown that it had a reputation when the defendant adopted the mark. Now, this was another trademark case on pharmaceutical products, Glow Eye and Glow Tab. The court said that this is meant for eye drops, and it is a nutraceutical product, and the difference between Glow Eye and Glow Tab is not enough, and the plaintiff was granted an injunction. In Wortman versus P. Mehta, one of the first cases where heavy damages was awarded to the tune of more than 2 crore rupees. In fact, the High Court followed the decision in Rooks versus Bernard and held that the defendant was making counterfeit products and is therefore liable to pay punitive damages. This is a new judgment of Bacardi, and this was against Bacardi versus Baheti. Baheti was using it for a non-alcoholic drink, and Bacardi was an alcoholic drink called Breezer. Breezer and Freeze was being used in the similar way, and the court granted an interim injunction restraining Baheti from using the trademark Freeze mix and the trade dress. The bottle was also similar in this case. Now let's look at copyright. Copyright is meant to be, protecting the author. There are various forms of copyright works: literary, dramatic, musical, say sound recording, computer program, cinematograph work, etc. It encourages people to, create original works and not copy others. Copyright doesn't mean the right to copy. It is a right which is given to a creator against copying. So a lot of times people say, oh, copyright is a right to copy. It is not. Now, some of the important judgments under copyright this is a case which most of us have heard of normally. And, in Delhi University, there was a photocopy shop which was photocopying some chapters from different textbooks and making a case mat and giving it to the students. And the question was whether this is fair use or not. The court held that because it is for educational purposes and it did not amount to infringement of copyright. Because it was fairness, it is qualitative and quantitative, but the court felt it was not copyright violation. This is a new judgment, IPRS versus Entertainment Network. This was rendered by the Delhi High Court in 2021. And the question here was, when an FM radio channel is playing the music, whether the copyright is to be taken from the owner of the song, I mean the lyrics, or only the owner of the entire sound recording. The court held that the underlying works are not utilized, only the sound recording is utilized, and therefore the permission from the author of the literary work, i.e. the lyrics, need not be taken. Let's now come to patents. There are three main steps that are to be taken care of when we look at patents. It has to be new, it has to be inventive, it has to have industrial application. Now, what is meant by new? New is what is not known before. If it is known or published in any form, it is not new. If it's used in a seminar or a conference, if it's in a newspaper or a trade journal, or even in a cartoon clip, it is not new. What is obvious? Obvious is adding of sodium and chloride. Sodium is known, chloride is known. Can someone imagine that adding of sodium and chloride would lead to common salt? Was it predictable? If it is not predictable to a chemist who knows the subject, it is not obvious. Obvious is from the eyes of a person who is skilled in the art. It could be a basic undergraduate or a postgraduate in the relevant field. Need not be a PhD, need not be a scientist. Someone who has basic knowledge of the subject, if he can think about the invention, then it is obvious. Otherwise, it's not. Industrial applicability. The invention should not be theoretical. It cannot be academic. It has to have practical application, economic advantage. It has to be cost effective as compared to the existing knowledge. Then, if you satisfy all these three conditions, the patent is granted. Every patent has a patent specification. It ends with the claims. The claims defines the monopoly which is granted. And if the defendant's product is falling within the claims, it is infringement. The defendant can file a suit. When a case is filed for infringement of patent, the defendant can argue that the patent is invalid and file a counterclaim. In that case, normally patent suits are filed in the commercial courts at the district judge level. None of the intellectual property matters can be filed below the district judge. It has to be an additional district judge or a district judge or a commercial court at the district judge level. It cannot go to the civil judge or a sub-judge or a munsif. These matters don't go there because there are specific provisions in the Trademark and Patent Act, in the Patent Act and the Trademark Act that say that these can be only entertained at the district level. Now, a large number of judges have asked this question as to whether the judge has to have technical knowledge. According to me, most judges did not have technical knowledge to deal with IPR matters. Any judge who handles civil or criminal cases can also deal with patent cases. But once you handle one or two cases, you will get the basic knowledge and it is easy from there on. So what can a defendant do in a patent infringement case? He or she can show that the patent is not new, it is obvious, and that there is no practical application to the invention. The threshold for practical application is very low. Even if there is a hope that this can have a decent exploitation, it is enough. And it need not be a very high threshold. If the invention is good, then injunction is usually granted. The judge has to merely see the invention and the documents which the defendant shows to show whether it was known in the earlier time prior to the patent. If the judge feels that no, this was not known, this was quite new when the patent was granted, then the injunction is usually granted. Usually in an infringement of a patent case, an affidavit is filed by an expert, and the judge has to look at the plaintiff's affidavit, the defendant's affidavit, and accept the view that appears more plausible. You can also order a short trial for one expert each, and you can decide the matter. Now, there are a large number of patent judgments which have come out in the last few years. In the area of pharmaceuticals, there is enormous amount of jurisprudence. The basic question is, if the molecule or the pharmaceutical product is new, then injunction is granted. But if the patent is invalid, if the patent was of a known product, then injunction is not granted. Now, this can be a little complex. This is Novartis versus Union of India. Let me tell you what is the concept of section 3D, which is very important because that is the main section which is considered when we deal with pharmaceuticals. Section 3D of the Patent Act says that if there is one known pharmaceutical substance, you've got one patent over it, you cannot get a second patent over the same thing by simply tweaking it a little bit here and there. Let me give you an example. In the case of Novartis, there was one cancer medicine which had a patent in the US and it was not filed in India. However, Novartis said, we have come up with a new salt form of this molecule and we want a patent for that. The question was, in section 3D, it says that if there is a new form of a substance which is known, then unless and until you show very high efficacy in the human body, you cannot claim a patent in that. You cannot extend the patent by simply saying that I have tweaked it, I have changed it a little bit, so give me a new patent. The term of a patent is only 20 years. So what happens is in a gap of 4-5 years, again and again, more and more patents are filed. This is called the concept of evergreening. This is not permissible under Indian patent law. This new form, salt form or any other form can be patented only if it shows very high efficacy. Unless and until very high efficacy is shown, you can get only one patent for one invention. That is the law in India. Section 3D, Novartis, Roche versus Cipla, all of them say the same thing. So I'm okay if you all wish to have this presentation. You can ask Dr. Gupta, it can be circulated to you. So I'm going to move on now to a next subject because I would like to deal with the internet and how IPR is being affected by the internet, because many of the cases that come before all of you in the Commercial Court Act could be related to the internet, how you exercise jurisdiction, etc. So I would like to come to that straight away. Okay, before I come there, let's look at designs. Designs is a very simple thing. If a design is registered, no one can pirate that design and it has to be protected. Let's look at a simple case of a design. For example, this teapot. This is a very unusual looking teapot. This design, if it's a registered teapot, no one can make a teapot which is similar. Design is meant to protect very small innovations, small manufacturers, SMEs, small scale industries. They can obtain these designs for innovative products and then try and protect them. Piracy of a registered design is not permissible under the Act. You can get an injunction, one can get an injunction and damages, etc. can be granted. For example, let us look at this judgment. This is important. This was a case where the famous designer Ritu Kumar had filed a case for one of her well-known designs. And the court held that because of Section 15 of the Copyright Act, if a product is manufactured more than 50 times and the design is not registered, then you cannot claim copyright in that design. So therefore, the injunction was refused. So the way in which this operates is, if a person has made a new design, it is compulsory to get it registered. You cannot claim a copyright in the design without registering it. So that's what section 15 says. Under section 15, if the design is reproduced more than 50 times, the copyright in the said design gets exhausted. So if the design is not registered, then it can't be protected. Carlsberg is again about a beer bottle, and I'm sure many of the persons who consume these products are aware of them. Now let us come to a very important aspect of the internet and IPR. This is one of the recent judgments of the Delhi High Court which I rendered. It was a case of defamation which was filed by Swami Ramdev. Now the case was that there was a book which was written in which there was a lot of allegations made against him. That book itself was injuncted by the Delhi High Court. However, somebody made a video of the content of that book and put that video online on YouTube. So the plaintiff filed a suit before the Delhi High Court and sought an injunction against Google, saying, please ask for the video to be removed from the YouTube platform. Google and Facebook argued that we will remove it only for Indian users and not in foreign jurisdictions. And they said that the Indian court does not have the jurisdiction to give an injunction which will operate globally. As you all know, when we open YouTube, we can watch any video which is there on YouTube. So if we want to remove it from YouTube, they said we will do what is called geo-blocking, and not global injunction. So this created a lot of this legal issue was raised by the defendants, and the question was whether Indian courts can direct Google to remove it globally. And it was a very complex case involving very complex legal issues of constitutional rights, because free speech was also raised. And one interesting case in Canada and US was cited before the court, and that was called Google versus Equistech. What had happened in this case was there was a pirated, counterfeited product being sold in Canada, and the plaintiff had filed a suit in Canada. The defendant did something very smart. The defendant agreed to the injunction, but what they then did was they moved their office outside of Canada and they blocked the counterfeit product only for Canada. Now, Equistech went to court and said, look here, there is an injunction from him selling these products, counterfeit products on the website. But now it is being offered in the US and other countries. So give a global injunction. The Canadian Supreme Court of British Columbia granted an injunction which was global, but Google challenged the Canadian Supreme Court's order in the District Court in California. And the District Court in California stayed the judgment of the Canadian Supreme Court. So in effect, what happened was, in Canada, the only Canada restricted injunction could be implemented and not a global injunction. So this decision was cited before the Delhi High Court. This may happen in any court nowadays, criminal cases, civil cases across the country, where things are being uploaded on Facebook, on YouTube, on Google, on Instagram, various other platforms. So what is the power of an Indian court? Can you grant an interim injunction or a final injunction asking the platform to remove it on a global basis? So what was held in this case was that if the information has been uploaded from India, then a global injunction can be granted because the cause of action is connected with India and it can be stopped by Indian courts. So that was one of the most important judgments now on the issue of global injunction and geo-blocking. Now let us come to another interesting case. When you go online, one can register many domain names. Snapdeal.com, Amul.com, Dabur.com, Dabur.org, Amul.org, Amul Milk, Amul Butter, Amul Cheese. You can keep on creating one after the other. So these companies realize that there are a large number of people who are going on registering domain names. So can a suit be filed against every domain name owner? How many thousands of suits can one file? So the cases have 2 or 3 suits have been filed in the Delhi High Court on all these trademark related cases. And the High Court has held that since these are well-known marks, the domain names should not be permitted to be registered by the registering authorities. These cases are still pending and the final outcome is yet to be seen. But the court was of the opinion that these are well-known trademarks and you should not be allowed to register domain names of these marks. There are a lot of jurisdictional issues that courts face in trademark related cases. The main thing in online is that it's very easy to hide the person who has put it up. It's very difficult to find the people who have put it up. Secondly, there are territorial limitations. It can be easily changed also. Instead of, for example, saying delhihighcourt.co.in, it could be delhihighcourt1.co.in, Delhi High Court 2. So how long will you keep on finding them and going on injuncting them? So this jurisdictional issue has created a lot of problems. And another issue that we face is that there are many of these platforms who come and say, we are only intermediaries. We are not liable to be hauled up in trademark matters like this. We do not want to be, for example, liable in damages, etc. in all these cases. So there are a lot of challenges that courts are facing in the online platforms. And one of the main judgments of the Division Bench of Delhi High Court on this issue is Banyan Tree, where the court held that if the defendant has purposefully availed of, if you see here, it says purposefully availed of the jurisdiction of the court, then the court can exercise jurisdiction. For example, suppose a suit is filed in Mohali in the commercial court and the court finds that the defendant is permitting, live streaming of a show on the internet which can be viewed by viewers in Mohali, then the commercial court can exercise jurisdiction if there is purposeful availment. Suppose a book is being sold online and you can purchase it from that jurisdiction, then you can exercise jurisdiction there. So Banyan Tree is a judgment which holds the basic tests on jurisdiction. And that judgment is worth reading. This is another case where, there was a hotel called Millennium, and the defendant, one could sit in Delhi and book the hotel room called Millennium. The court said that on the basis of the extracts of the defendant website, which indicate that the defendant operates in Delhi, defendant services could be booked from Delhi. The court found that there was a specific targeting of customers in Delhi. Hence, the court had jurisdiction to entertain the suit. So this is Millennium and Copthorne. This is another very interesting case. Making a booking reservation, even if the same does not materialize, is part of carrying on business, inasmuch as the hotel which has taken the booking, even if it has not received payment, being unable to turn back a customer in pursuance to that booking, the defendants, by showing their websites, their location to be Delhi, are found to be attracting and luring the customers into believing that the hotels and resorts are at Delhi, though territorially speaking outside Delhi. So by applying the test of banitry, the court held that there was jurisdiction. This was a case where Juggernaut and the defendant was in New York, but they were targeting Indian viewers by Indian tourists and giving details about various tourist places in India, etc. So even though the defendants are residents of a foreign country, the court found that it had the jurisdiction to entertain this matter. So this is another judgment. This is another case where, the defendants were rogue websites which were showing pirated movies. And the court said, all these are rogue websites, even though they may be based abroad, they have to be injuncted. And as and when a new rogue website comes up, the plaintiff can go to the registrar and ask for blocking of the website. So this is what is called a dynamic injunction, which was granted in this case by the court. In a large number of cases, we are told that, you cannot pass an injunction against the platform. For example, whether it is Amazon, whether it's Google, Facebook, Snapdeal, they say we are intermediaries. Now the question is, can the commercial court pass an injunction order against them? And if so, in what manner? So this is laid down in section 79. If you find, the question that the court has to consider is whether this platform is active or it is passive. If it is an active platform, they can be held responsible. If it's a passive platform, you will have to ask the takedown of the infringing or the objectionable video or image or whatever. Now, in this case, the key elements, some of the key elements to hold whether what is active, what is passive is, if the seller is identifiable on the platform, if there are reviews for the product. When we go on Amazon, we will find some products are supported by Amazon, lot of reviews are given, you make payment, then the packaging may be coming with the e-commerce platforms packaging. There are arrangements with various sellers on the platform. If there's a customer complaint, payment, who is taking the payment in this? All these are the factors which are looked at to decide whether the platform is active or it is passive. Now, can intellectual property disputes be arbitrable? Yes, they can be arbitrable, so long as it is in personam dispute. In rem dispute cannot be arbitrable. So if there is an invalidity of a patent, invalidity of a trademark, that can only be held in a court. But if there is a franchisee or a licensee dispute, it can be arbitrable. Now, coming to the commercial courts, as you all know, commercial courts are set up in more than 24 courts in the country, and the value has been reduced from 1 crore to 3 lakhs. And the twin test of whether the subject matter and the pecuniary jurisdiction is there has to be checked. If it is a commercial dispute under section 2C and the dispute is above 3 lakhs, it comes to the commercial court. And there are various strict timelines, as you know. These are the timelines in Commercial Courts Act. The way I look at it, it's possible to complete a suit within 1 to 1.5 years from the date of filing. In Delhi High Court, we are able to do that because we are strictly following the principles of Commercial Courts Act for pleadings, etc. There is only one bottleneck for final arguments, which hopefully, if we have more courts, that should be getting sorted. But we now see that within 4 to 6 months, the matter finishes admission denial, finishes pleadings, comes for issues, and within 6 months or 8 months after the issues are framed, the trial can be concluded. Now, this is the last aspect of my presentation, Specialized Forum for Intellectual Property Disputes. Last year, the IPAB was abolished. There were a large number of cases in the IPAB. This is the notification, 22nd April 2021. After that, the Delhi High Court has notified the IP division, and we have also framed new rules for the Delhi High Court IP division and High Court of Delhi governing patent rules. These are rules which are in addition to CPC and Commercial Courts Act. And in the last more than 2-3 weeks, we are functioning exclusively IPR division in the Delhi High Court with 2 judges dealing only with IPR matters. Our High Court has approximately 4,000 to 5,000 IPR cases. And we now expect that going forward, since the IPAB has been abolished, almost all courts will be getting appeals from Trademark Office, original petitions from Trademark Office and Patent Office. So it is more and more necessary for commercial court judges and high court judges to be very familiar with IPR matters. And in Delhi High Court, we have set up the Ipr Tribunal. These are the kind of cases which are heard in the IPR division. Appeals from Section 91 of Trademark Act, 72 of Copyright Act, 117A of Patent Act. Now all this will be coming to the High Court, these appeals. And these are all the original petitions which will be coming to the High Court going forward across the country. So we expect, and now what we've done in the Delhi High Court is to merge all IPR cases, even RFAs, FAOs, CRPs, CMAs, EFAs, etc. in the IPR division. And this was prepared after conducting a thorough analysis of various procedures governing the IPR regime in US, UK, EU, Japan, and Australia. And we held a very big seminar last week, 2 weeks back. And the features of all these rules you can always see. The rules are available on the Delhi High Court website. And we have given a large number of guidances for litigants, clients, lawyers, how to draft, how to compute damages, how to draft a patent suit, what all should be there in that. We have also provided for technical law researchers to be recruited by the IP division so that engineers and people who have chemistry, knowledge of chemistry, biotechnology will now be engaged by the High Court for assisting the judges. And this is in detail, all the patent suits and everything. And I would like to end my presentation with this. And I'm sorry, I was not aware of the platform on which this was happening. And that's why there may have been a little bit of a glitch in the initial stage.
Thank you so much, Justice Singh. Listening to you and looking at the presentation that you have made makes me feel so good this afternoon now. This presentation was intellectually motivating. The entire presentation was so engaging. I'm sure the judicial officers, kind of an entertainment to them as to how you have to enjoy the disputes which come before you. This presentation, in fact, focuses on that aspect as such. I have always urged the judicial officers that you must enjoy the work that you do, and in that particular process, you'll be able to contribute immensely as such. And therefore, this particular motivation, in such a pleasant, comfortable manner that you have presented, particularly the issue of global injunctions, so interesting, engaging at the global level as such. And therefore, the parameters of intellectual property disputes are not nationally or territorially limited. They are internationally focused in that particular context. My expression of gratitude to Justice Singh for sparing your time. I know how you are busy with the contributions that you're making as a judge and otherwise too. I would only say continue with this particular domain which you have created, virtually created a jurisprudence of its own. It has been a pleasure to listen to you and look forward sometime physically to have a presentation to you, to have the real joy of that. Thank you so much, Justice Singh, for being with us on this platform.
Thank you.
Thank you so much.